exactly does it mean when the Supreme Court say they reserve judgment in a matter?
Yeah, very simple. If a matter has been copiously hired, I mean, you file your processes, and the court give you a clear date for hearing, and after having heard from you, ordinarily the court will give you a date for judgment. But when it's said that a judgment is reserved, you know, there is no definite date, but that issue of date will be communicated later. So when a judgment is reserved, it means that it is adjourned for judgment, but the specific date is actually unknown. It can be today, it can be tomorrow. So they have reserved judgment in order to deliver judgment after you have exhausted, you know, whatever you have filed, you know, in terms of maybe oral amplification or adoption of your written brief. The court will now say we have reserved judgment, meaning we are postponing judgment to a later date, but the date is clearly unknown. It can be today, it can be in an hour's time. The communication will be done by the registrar of the court and say, come, and then, of course, listen to the judgment of the court. So that's what it means in simple terms.
Thank you for explaining that. I think the second question will be why? Why do they reserve judgment? Because I'm sure that you've heard all manner of whisperings behind the scenes as to why this happens. Can you tell us why this happens within the jurisdiction of the courts?
Of course, after you have heard the parties, I was in court last Tuesday. If the counsels have filed their brief, I'm sure that Tuesday they would have adopted those briefs that day, pending judgment. But unfortunately, the briefs were not filed. So the court gave yesterday as the date they will now listen to all parties. Gave them a deadline, Monday, for them to file all their processes, which is actually what happened. They finished filing their processes, and then yesterday was for argument. The court need to study what they have actually written and then said in oral amplification before writing judgment. So they can't just immediately enter into it. It is a constitutional issue, as Chamberlain has actually pointed out. Very grave constitutional issue that requires proper appraisal, looking at what the issues are and then making a pronouncement. Because again, the issue of jurisprudence is key. It is already an established fact that on issue of internal matters of the political parties, the court, as far back as in the 80s, have laid it down that, look, the courts do not interfere in matters that are considered internal. But over time, exceptions, you know, grew. That if what you are you know, coming to court to argue has to do with breach either of your internal rules or your guidelines or your constitution or even the Constitution of Federal Republic of Nigeria or the Electoral Act, the court will actually listen to that person who has come to court for issue of grievance, you know, to be redressed. So over time, they now make it a statutory provision. Even the current Electoral Act also has it in Section 83, that you do not interfere in internal affairs of the political parties, except under those note grounds were actually properly specified. The Act even went further to now impose punishment on lawyers who come to court over matters that are clearly regarded as internal affairs of the political parties. I think that the lawyer will be asked to pay 10 million, not even the litigant. A lawyer who accepts a brief that has to do with internal affairs of a political party and who comes to court to ventilate a matter that is purely an internal affair of the political party will be asked to pay fine now. And lawyers are arguing whether that is not denial of access. You know, but it's a different ballgame entirely. What we're saying is that issue that will be determined is very grave constitutional issue. So they need to take time, look at what parties have filed, and then give the judgment that will satisfy the aspiration and yearning of all the parties that are before the court.